Right, this is LAWS12066, and this is continuation of land law topic 3, dealing with the balance of the exceptions to indefeasibility of title. Now, in the previous lecture, we dealt with the fraud exception, which is fairly substantial. In this lecture, we're going to deal with the what's referred to as the in personam exception and other statutory exceptions that exist under the Land Title Act in Queensland. And we're going to just see how these various further exceptions work together. So I'm just going to share the slides again. Just before we go back to that, just go back and we'll see that. So you can see there we're doing the in personam exception to indefeasibility and other exceptions to indefeasibility. And the other area that we look at in this lecture is the role of the register and the registrar's powers to correct the register under the Land Title Act. Now, the role of the register, what's that mean? I mean, that is about what is the implications of the Torrens register, the public Torrens register. And we look at refer to a leading case, Personam Berger Brothers, which is about what is it we can look at when we look at the register. That's essentially, you know, this idea of can we go behind the register, coming back to this curtain principle that you know, what stands behind the register is essentially not our concern, or not, you know, we're interested in what's on the face of the register, but when we come to that toward the end of the lecture, we'll see what the Bursell case has to say to us in that regard. The other point that we need to be aware of today in the modern period is the fact that there are some up to 3 jurisdictions currently in Australia who have moved towards the privatisation or commercialisation of the Torrens register. That obviously is a change of landscape. That is, the register will be managed by a private entity in those jurisdictions, not in Queensland. Queensland is still under the authority of the Department of Natural Resources and Mines within Queensland government. But in those states where this has occurred, it hasn't been, the whole process hasn't been completely outsourced. I mean, there is still the government agency that overarches the process and that takes accountability and has a regulatory role. But you can understand that the arrangements are different, and issues around the assurance that is there in terms of Torrens title, and in the next lecture we'll look at the compensation fund, which links back to the assurance principle. That is still anchored in the legislation, but we might ask, well, how does that work in a privatised or commercial context when that's being managed by a private entity? But again, as I said, that's not in Queensland, but it is part of the suite of these developments that are taking place. Just to reinforce the idea that land law is dynamic, not dry as dust, and there's lots of change occurring, and we need to be mindful of that. So we're focusing, been through fraud, we're looking at in personam exception to start with. And you can see there that initially in Queensland, which is different to other jurisdictions, in almost all other jurisdictions, the situation is found, this exception is found within the body of case law, And it basically arose, this in personam or personal equity exception arose from the comments that were made by Lord Wilberforce in Fraser and Walker that talked about this idea of rights in personam against the registered proprietor. And essentially it goes to the idea that a registered proprietor can't hide behind the registration to obviate responsibility for promises which had been given prior to becoming the registered proprietor. And there's a range of situations in which that can arise. And there's a debate around what is this exception completely about. And there's been suggestions that the use of the phrase personal can be a little bit misleading. And the nature of how the exception is working within a system of land registration, it has also been put forward as an idea that's a bit controversial, and how, you know, but and it also raises this ongoing tension, if you like, or rub between the system under the legislation, the Torrens system under the legislation on the one hand, and the continuing role of equity on the other, and general law, despite the existence of the framework embedded in the legislation, in the Torrens Acts. Now, I just mentioned a bit earlier that in Queensland our situation is a bit different to other jurisdictions. We actually have a section within the Land Title Act, section 185(1)(a), I'll show you that in a moment, that deals with what's referred to as the personal equity exception. Now, just before we get to that, and that the White and Thomasall case, which is referred to after that, is a case that was just interpreting that provision, that section 185(1)(a). So that's an important Queensland case in the context of understanding the reach of that provision within the Land Title Act. But one of the points to, I'll just stop screen sharing that for a moment. One of the points that is important to grasp is that there's a large body of case law that's emerged over time with respect to the in personam exception, dealing with a number of features and aspects and situations that arise and get tossed up. And it's important that what we need to get is a sort of a grasp of the nature of this exception, how it might work, and see some examples, remind ourselves about the legislative provision in Queensland. Few of the key cases, yes, but then have relevance in light of our position in Queensland with this section in the Land Title Act. And then also the role of this idea of unconscionability. We'll come back to that shortly. It's an important idea. We want to ask, is it a requirement, or is it an optional criterion? Because it's a powerful idea. And essentially, the exception generally is going to the conduct or the conduct of the registered proprietor in terms of attempting to use the registration of which gives them their interest under the Torrens system as a way of saying that, well, look, I don't need to worry about those promises that I made. I'm now a registered proprietor, so there we go. Nothing more to be said. Well, no, the law, equity won't countenance that. Okay, so that's where we're going, folks, before we get to the next aspect and thinking about some of the other exceptions as well. Just so in your casebook, and I think this is nice because in some of the books in this area, the discussion just does go on and it's quite long and elongated. But I think that they've got the balance right. That's partly one of the reasons I've chosen the book in this particular area. So you will see if you consult the casebook, rights in personam, or the personal equities exception, starts at paragraph 5.100 and goes through to 5.116, and that's on pages 487 through to the top of, halfway down, 504 of the current edition of Edgeworth's Sackville and Neath. So, that's as I was saying, so that's 487 to 504. So that's 13, about 17 pages, which is, it's manageable, but the material is a bit challenging. The decision of Barr and Nicolay number 2, 1988 High Court decision, fairly substantial extract on that. Barr and Nicolay actually comes up in both in relation to the fraud exception and also in relation to the in personam exception. But the substantial case extract is under the in personam exception, but there is also a discussion of that in the preceding paragraph under supervening fraud in the casebook that you can have a look at. So Barr and Nicolay is an important case. Just want to share with you now the relevant legislative provision. Right, so you can see there that we're looking at section 185, the exceptions to section 184, 184 being the quality of the registered interest that is had under the legislation. And we're looking at the first one here, so it's subsection 1A. A registered proprietor of a lot does not obtain the benefit of section 184, which is the quality of what the registered interest gives, for the following interests in relation to the lot and equity arising from the act of the registered proprietor. So again, you can see that what's happening here is that, and this is, the Queensland Act is more modern more modern version of Torrens legislation. So it's basically capturing what had been documented in the case law about the type of exception that was recognised as the in personam exception. Here it refers to an equity arising from an act of the registered proprietor. So something that the registered proprietor has done, it refers to an equity. Now, this is a little bit controversial. I just want to take you to an article, which I think I've given to you on the Moodle site, by Moses and Edgeworth. Edgeworth does seem to be quite influential as a writer in this area, doesn't he? Brendan certainly is, no doubt about that. And it's an article which they've titled "Taking It Personally, Ebb and Flow in the Torrens System's in personam exception to indefeasibility." I'm not going to go through all of it, but you can have a bit of a look at it if you like. It's I just set up on the Moodle website, and it's 2013 Sydney Law Review, volume 35 at 107. But just the point that I want to tease out just at the minute is that on page 115 of their article, the authors talk about this in personam exception, personal equity, and this relation. It's about personal conduct, and then they proceed to make the point that it's important to realise that the exception can actually be grounded both in common law and equity. It can be in common law in some situations. So that the nature of the right which we're talking about here is a bit controversial. That's the point I'm wanting to just tease out. We are governed, or governed, I think it's fair to say as well, by the legislation in Queensland. That doesn't not the case in other jurisdictions. So there's more authority in Queensland really to say that we're looking at an equity pursuant to section 185, 1A. You could also say, I suppose, it's certainly arguable that the in personam exception, which might exist beyond that section, is also something that can be argued, even in Queensland. But today, we do have this section, and we are tending to focus that, as other jurisdictions do not have that. Okay, so that's important to appreciate. I'll just stop screen sharing that, and we'll just go back to the slides. So we've got that provision. We've also got, as I said, the White and Thomasville case that you can have a look at, which discusses that section and its application and how we are to understand it. And I'm just going to stop screen sharing that for a moment. Right, now before we consider the White and Thomasville case in relation to its interpretation of the nature of the equity exception under section 185(1)(a), we need first to have a look at Barr and Nicolay as leading High Court decision on this exception. We'll come back to White and Thomasville. The reason we're doing that is because part of the discussion in White and Thomasville involves the relevance of unconscionability in how we understand that exception. So we'll start with Barr and Nicolay number 2, and then we'll come back to White and Thomasville after we've also considered the relevance of this unconscionability feature within this exception. So I'm just going to screen share again. Let's go back to the slides. So in Barr and Nicolay, what we found was that we had the Barrs were in a situation where they're unable to raise funds for the development of a property. So what they decided to do was to finance the development by selling their property to an individual on terms that they would then lease for a number of years the property and then have the capacity to repurchase the property back from that person for a specified sum. The person that they were then involved with sold the land to a further entity. In the contract between those parties, it included a clause acknowledging that original agreement with the Barrs, and that was also part of the repurchase or the repurchase aspect by the Barrs. Thompson, who was the final purchaser, subsequently confirmed orally to the Barrs that he'd recognised this clause in the contract with Nicolay. However, once he became the registered proprietor and when the Barrs attempted to undertake the repurchase, Thompson then refused to sell. I'm the RP, sorry, all bets off. And as I said to you, this case made observations in the context of fraud, but we're just going to have a look at it in the context of the in personam exception. And you'll find that in your casebook, the extract gives you extracts from the judgments of the joint judgment of Mason and Dawson, and Wilson and Toohey, and also Brennan. And then there are some interesting questions following that, just exploring the dimensions of that case. Stop screen sharing that for a moment. Right, so we find that in Barr and Nicolay that we had various judgments. We had the joint judgment, as I've already indicated, of Mason and Dawson, and we also have the joint judgment of Wilson and Toohey, and then the separate judgment of Brennan. Now, the judgment of Mason and Dawson started by looking at what transpired in terms of whether or not it could establish fraud. And in the end, they took the view that it could establish fraud. And we've seen that in the context of the previous lecture in regard to fraud, when the Barr and Nicolay case was referred to in the context of supervening fraud. However, the judgment also looked at these obligations that had been entered into, which were in an agreement, whether or not it could give rise to a personal equity. And Mason and Dawson actually took the view that it could constitute a trust. So they said, for example, in the absence of the manifestation of a clear intention to create a trust, the courts have been reluctant to hold that a trust exists. The reluctance to accept that the parties have created an express trust has induced or has led the English courts to suggest that the courts could recognise a constructive trust through an interpretation of the intention of the parties. Again, this is in this context of the agreement that had been entered into and the undertakings that had been made on the facts as I've already recounted them. In the end, Mason and Dawson took the view that there was actually an express trust, not a constructive trust, in terms of those undertakings that had been made, and that the registered proprietor should be held to that obligation, which of course is an equitable, constitutes an equitable interest and carries implications. Wilson and Toohey analysed the facts in a slightly different way and came to the view that there was no grounds for fraud in their opinion, but they ultimately felt that there was sufficient to establish a constructive trust. They didn't come to the conclusion there was an express trust in the nature of how Mason and Dawson reasoned, but they resolved that there was a constructive trust. And this, of course, was in the nature of a clear interest that equity would recognise. Brennan, on the other hand, focused on the idea of the unconscionable nature of the actions to resile or walk away from the undertaking which had been made by the registered proprietor. And that tended to characterise the way he came to the conclusion that there was also a constructive trust. He says, for example, a means by which equity prevents the fraud is by imposing a constructive trust on the purchaser when he repudiates the unregistered interest. It's also just a point to note here is that the application of the personal equity or the right in personam often arises in the context of an assertion being made by a party that claims to have an unregistered interest. And we haven't yet done that. We'll do that in the next lecture, but just bear that in mind. So that leads on to the idea of the role of unconscionability. You can have a look, before we get to that, you can just have a look at those questions by way of discussion around Barr and Nicolay that are posed in the casebook at 5.102, and particularly in terms of what follows at 5.106 in terms of the types of causes of action that can be asserted against a registered proprietor. So the situations and the circumstances which most typically underpin the claim that's founded as a right in personam against a registered proprietor. And you can have a look at discussion there on pages 495, essentially to 496 of your casebook that looks at those circumstances. But just on this idea of unconscionability, there's debate around that in terms of is it critical? We've seen that Brennan and Barr and Nicolay number 2 refers to unconscionability. Is it a necessary component of establishing the in personam right? And I just want to refer you to a discussion of this point in the latest edition of Butt's Land Law by Edgeworth, 7th edition, 2017. This is paragraph 12.900, where Edgeworth says, many authors assume that there can be no personal equity or right in personam unless the proprietor's conscience is affected by the circumstances that gave rise to the legal or equitable cause of action. On this view, a legal or equitable cause of action is insufficient unless the circumstances also render it unconscionable of the proprietor to obtain or retain the registered interest contended for. He then goes on to say that, however, another view holds that unconscionability is relevant only where it is an element of the cause of action asserted. Where it is not, there is no super-added requirement of unconscionability. And in this context, he refers to the White and Tomasel decision, and I'll just come to that in a moment. This seems the approach more consistent with authority, policy and principle, given the underlying rationale, as expressly endorsed in Fraser and Walker, that what is required is a legal or equitable cause of action. So Edgeworth in Butt's Land Law is saying that this so-called super-added requirement of unconscionability in fact is not a requisite requirement, but may be relevant where it is part of the course of action that's being sought to be established. So if we now come across to the White and Tomasel case, and recall earlier in the lecture I indicated that the White and Tomasel case, of course, Queensland decision specifically discussing the Queensland section 1851A, which is a unique provision in relation to this exception to indefeasibility. And you'll find White and Tomasel discussed at paragraph 5.110 of your casebook, pages 498 to 499. And the points that come out of the White and Tomasel case is that the circumstances where the respondents had argued that they had an indefeasible title and could not be ordered to retransfer the land to the appellant, as they had simply acted in reliance on a court order and had done nothing unconscionable. In the Court of Appeal, Justice McMurdo said that unconscionability should not be a universal requirement for enforcing a personal equity against the registered owner, as otherwise, for example, the rights of a purchaser under an uncompleted contract of sale of a registered interest would not be enforceable. However, Davies, this is over on page 499, Davies, Justice of Appeal in dissent, held that no equity can be enforced against the registered proprietor unless his acts make it unconscionable for him to retain title and the circumstances did not give rise to such an equity. From one perspective, the view of the majority represents an unwarranted extension of the in personam exception, but from another, the majority position may be seen as not in any way impairing indefeasibility because the in personam rights in general do not detract from the principle of indefeasibility. They simply reflect rights that the registered proprietor is subject by virtue of their own acts, or rights that the registered proprietor has become otherwise affected by, such as in the instance overturned by court orders, which was the circumstance in the Tomasel case. So and this is a bit, it's a bit befuddling, but what you've got to try and grasp is that firstly, that in Queensland, the personal equity exception is located within or sources from the Land Title Act, section 1851A, and that's different to other jurisdictions, so that makes a difference in Queensland. Secondly, we've got case law showing us how the exception generally works, not always in the context of the equivalent provisions of 1851A, but how it works generally in terms of the way the courts have interpreted it. Essentially, it is about the fact that a person who becomes a registered proprietor cannot walk away from undertakings or commitments or promises made prior to becoming a registered proprietor merely because of the act of registration. And those undertakings, those promises, those agreements may be able to be enforced either at law or in equity, though more so in equity, but there are situations that general law or common law will recognise. And the role of unconscionability in that process is somewhat unsettled, but I think it's arguable, and now this is my position coming forward a bit, it is arguable that unconscionability has a central and significant role to play in the recognition of this right and its capability of being enforced against a registered proprietor. So that's the challenging exception in terms of a right in personam. The casebook goes on and looks at some, what it refers to as some special equity cases, and these involve personal equity and a breach of trust, paragraph 5.113, personal equities and mistake, 5.114, paragraph 5.114, personal equity and unlawful action by public authorities, 5.115, and also in relation to easements, 5.117. There's a range of cases that have been, brought up these circumstances. I suppose that it's fair to say that we have the more significant number of cases in this area of breach of trust, and you can see in the notes and also in casebook, Macquarie Bank and 64 Throne, a Victorian decision from 1998, Farrer Constructions and Say that's a 2007 High Court decision, and also somewhat more recent Queensland decision in Tara Shire Council. So have a bit of a look at those cases. All right, so I'm just going to go back to the slides. So we can see there the different further categories of situations involving the personal equity exception or the right in personam exception. The category with regard to breach of trust, which I was referring to just a moment ago, you'll find that, as I mentioned, discussed pages 501 to 502. And you will see there that there's discussion of the Farrer Constructions case, which is the High Court decision 2007. And you can see it's referring back to the earlier 19th century English decision of Barnes and Addy. Now, you'll notice there that there's a discussion of the two limbs that are set up under Barnes and Addy, and with regard to trustee and the fiduciary obligations, and there's the two limbs essentially refer to what's identified as recipient liability and accessory liability. You can see that in the first paragraph there under 5.113. Farrer Constructions essentially confirms, as you can see in the following paragraph, in the joint judgment by Gleeson, Gummo, Callanan, Hayden and Crennan, that the court came to the view that the breach of trust or fiduciary duty required under the second limb, that is the accessory liability limb in Barnes and Addy, must be dishonest and fraudulent. And the majority in Farrer Constructions, as you can see a bit further down that page, followed the interpretation also in Macquarie Bank and 64 Throne, which was the 1998 Victorian decision, that dishonesty in the second limb of Barnes and Addy, that's the accessory liability limb, coincides with the concept of fraud as an exception to indefeasibility under the Torrens statutes. So the point being here that there's a sort of an overlapping situation here between the fraud exception and some features of the in personam or personal equity exception, particularly in these jurisdictions where they aren't benefited from the particular provision within the Torrens statute as in Queensland through section 185(1)(a). So the way you need to approach this is to look at that discussion in the context of the situation in Queensland. And for example, the Tara Shire Council decision, which is a 2002 decision of the Queensland Court of Appeal, it actually, this is over on page 502 of your casebook, it actually held that a registered owner who took property knowing that it bound him to hold the property on trust for the council, and it so the situation in the Tara Shire Council case is also helpful in this context, because it's dealing with the Queensland position. But again, you can compare that to the approach in Farrer Constructions and also Macquarie Bank and 64th Throne. Interestingly, the last paragraph there on this discussion under this particular category of personal equity exception on page 502, the authors of the casebook comment that one consequence of the ruling in Farrer Constructions is that a purchaser who has been gazumped by the registration of a transfer to another purchaser cannot compel the latter to transfer the land to him, even if the second purchaser took with knowledge that the vendor had already sold the land. Right, and that outcome can also be reflected upon in terms of the constructive trust arrangement, which was essentially the overarching majority's position in Bar and Nicolay number 2. And then you can have a look at those other exceptions, and there's some case law on those, and you can work your way through that. It's not as challenging as the earlier discussion. The main point here is to see that it is an established exception, and it has a degree of fluidity around it. In Queensland, as I've emphasised, we need to go back to the relevant provision in the Land Title Act. We have this body of case law, however, that is explaining the nature of how it works, and within that, the significance and the nature of the concept of unconscionability and how it plays a part in holding the registered proprietor to promises or undertakings that had been made and which give a right to another against the registered proprietor despite the fact of registration. Right, I think it's taken a little while to get through. We might finish here, and then I'll do another recording for the last section, which is on the register and the Bursell and Berger brothers case, and then also come back to those last exceptions. So I'll do an additional recording or further lecture on those before we then are able to move on to the final instalment on torrents. It just takes a little while, folks, to explain it, and I think it's best to be done in that way rather than trying to just truncate it into one short presentation because of the complexity of the material at hand. So, see you in the next lecture.